didn't hear me. Okay, Ms. Mosby, would you please get the jury into the courtroom?
Sorry.
Attorney Samuel Masradian and Attorney Farrah Nixon. Let the record also reflect that the jury is now present and seated in the court. Members of the jury, the defendant, William Ray Portier, stands charged by information with the offense of assault causing bodily injury. Alleged to have been committed in Jefferson County, Texas, on or about the 10th day of April of 2023, To this charge, the defendant has entered a plea of not guilty. I now give you the law that applies to this case. Our law provides that a person commits the offense of assault if the person intentionally, knowingly, or recklessly causes bodily injury to another. So that you may better understand the nature of the offense with which the defendant is charged, I'll now define certain terms and words. The term bodily injury means physical pain, illness, or any impairment of physical condition. A person acts intentionally or with intent with respect to a result of his conduct when it is his conscious objective or desire to cause the result. A person acts knowingly or with knowledge with respect to a result of his conduct when he is aware that the conduct is reasonably certain to cause the result. A person acts recklessly or is reckless with respect to the result of his conduct when he is aware of but consciously disregards a substantial or unjustifiable risk that the result will occur. The risk must be of such a nature and degree that its disregard constitutes a gross deviation from the standard of care that an ordinary person would exercise under all circumstances as viewed from the actor's standpoint. In this case, evidence has been introduced that the complainant has previously been convicted of a misdemeanor offense. The law permits this evidence to be introduced only for purpose of aiding you. If it does for determination in passing upon the credibility of the complainant as a witness in his own behalf, and you cannot consider this evidence for any other purpose. Therefore, if you believe from the evidence beyond a reasonable doubt that the defendant, William Ray Portier, did in Jefferson County, Texas, on or about the 10th day of April 2023, did then and there intentionally, knowingly, or recklessly cause bodily injury to Jason Warden, hereafter styled the complainant, by punching him about the face, you must next consider self-defense. Self-defense. A person's use of force against another that constitutes the crime of assault causing bodily injury is justified by self-defense when the person reasonably believes the degree of force used was immediately necessary to protect the person against the other's use or attempted use of unlawful force. Self-defense does not cover conduct in response to verbal provocation alone. The defendant must have reasonably believed the other person had done more than verbally provoke the defendant. Burden of proof. The defendant is not required to prove self-defense. Rather, the state must prove beyond a reasonable doubt that self-defense does not apply to the defendant's conduct. Definition: reasonable belief. Reasonable belief means a belief that an ordinary or prudent person would have held in the same circumstances as the defendant. Application of law to facts. To decide the issue of self-defense, you must determine whether the state has proved beyond a reasonable doubt that either, one, the defendant did not believe his use of force was immediately necessary to protect himself against Jason Warden use or attempted use of unlawful force, or two, the defendant believed his use of force was immediately necessary to protect himself from the defendant's belief was not reasonable. You must all agree that the state has proved beyond a reasonable doubt either one or two listed above. You need not agree on which of these elements the state has proved. If you find that the state has failed to prove beyond a reasonable doubt either element 1 or 2 listed above, you must find the defendant not guilty. If you all agree the state has proved beyond a reasonable doubt each of the elements of assault causing bodily injury, and you all agree that the state has proved beyond a reasonable doubt either 1 or 2 listed above, you must find the defendant guilty. General instructions. All persons are presumed to be innocent, and no person may be convicted of an offense unless each element of the offense is proved beyond a reasonable doubt. The fact that a person has been arrested, confined, or indicted for, or otherwise charged with the offense gives rise to no inference of guilt at the trial. The law does not require a defendant to prove innocence or produce any evidence at all. The presumption of innocence alone is sufficient to acquit the defendant unless the jurors are satisfied beyond a reasonable doubt of the defendant's guilt after careful and impartial consideration of all the evidence in the case. The prosecution has the burden of proving the defendant guilty, and it must do so by proving each and every element of the offense charged beyond a reasonable doubt. And if it fails to do so, you must acquit the defendant. It is not required that the prosecution prove guilt beyond all possible doubt. It is required that the prosecution's proof excludes all reasonable doubt concerning the defendant's guilt. You have a right to consider all the facts that are shown by the evidence and to draw natural and reasonable inferences from such facts. You alone have the authority and duty to determine what the facts are. In evaluating the evidence, you must totally disregard what you believe is my opinion about any factual matter. You cannot question the bailiff concerning the testimony or the law, nor should you discuss the case in her presence. If any question develops during your deliberation, it must be reduced to writing, signed by your foreperson, given to the bailiff. The question will then be answered by the court as soon as possible to the extent allowed by the law. Questions and comments of the attorneys do not constitute testimony and must not be considered as evidence. You must also disregard any statement of the attorneys that is inconsistent with the law contained in this charge. Any physical exhibits admitted into evidence will be furnished to you by the bailiff upon your request. You must not consider facts that have not been introduced into evidence or legal principles not contained in this charge. It is improper for you to discuss or consider anything which you know or have learned outside of the testimony presented to you and the law contained in this charge. If you should discover that you have any outside information, you should not mention this information to any other juror, nor consider it yourself in arriving at a verdict. Our law provides that a defendant may testify on their own behalf if he elects to do so. This, however, is a privilege accorded to the defendant in the event he elects not to testify. That fact cannot be taken as a circumstance against him. I'll strike that.
No objection.
Yeah. I don't know. You are the exclusive judges of the facts proven, the believability of the witnesses, the weight to be given their testimony. However, you must be bound by and strictly follow the law contained in this charge. Your failure to follow the law could result in a mistrial being declared and your deliberate violation of this charge could subject you to being held in contempt of court. After attorneys present their arguments, you will retire, select a foreperson, and consider your verdict. The arguments are not evidence, and you should give the arguments only the consideration you feel they deserve during the evaluation of the evidence. It is the duty of your foreperson to make certain that your deliberations are conducted in accordance with this charge. After you have reached a unanimous decision, your foreperson should sign the appropriate verdict attached to the charge. In returning your verdict, it is your responsibility to make certain that justice is done in this case. The last page of this verdict form is the verdict form, okay? And it has two parts, the top and the bottom. The top says, we the jury find the defendant not guilty as charged in the information of assault causes bodily injury. If that is your verdict, your foreperson will sign on the top line. And the bottom says, we the jury find the defendant guilty as charged in the information of assault causes bodily injury. If that is your verdict, then your foreperson will sign on the bottom line. Does everyone understand? Okay. State, are you ready?
State's ready, Your Honor.
Defense, are you ready?
Ready?
Okay. And we agreed on 30 minutes. Is that correct?
Yes, Your Honor. At maximum.
Yeah, 30 max. You could use less, of course. At this time, Mr. Maseratian, the state has the right to open and close. Or you going to have an
The state will waive its right to open and reserve its right to close.
okay? At this time, Mr. Kimler, you may proceed.
Thank you, John. Apologize for the delay. We had to work on the charge, written document, take back on the. Get some things straightened out with that, so there was some delay, thus for starting the quarter after before. I'll endeavor to be brief. I know you're probably anxious to get back there and begin your deliberations, but there are some things I'd like to cover with you before you start that process. First thing I would like to, the court is instructing you from the general instructions at the very end here, that it's your duty to see that justice is done in this case. I would simply suggest to you that you should, infer from that it's your obligation to actually return a verdict. And what I mean is that if you go back into the jury room and after good faith deliberations amongst yourselves, you find yourselves unable to reach a unanimous decision, it's not some sort of failure on your part to see that justice is done, that you can't reach a verdict. If you go back there to the jury room and engage in good faith deliberations based upon your reading and common sense and evaluation of the evidence as you see it, and after that, the give and take of discussing that amongst yourselves, you find yourselves at an impasse and you cannot reach a unanimous decision, it's not a failure. You're about to see that justice is. Again, I would suggest to you that the failure arises that if one or more individually give up what you think is the correct outcome, the correct verdict of guilty or not guilty, if you give that up simply because you feel pressure to return a verdict, that you change your vote simply to return it. That would be an abrogation of civil justice is done because you're giving up what you think is the correct outcome simply to return a verdict. It's not incumbent upon you, it's not imposed upon you as an obligation to return it. If you can't, you just have to send a note out, let the mayor know that you can't reach a verdict, and then we'll take measures if you breach it. And it's called a hung jury, it happens all the time, and there's nothing that is unusual about it. If you can't reach, well and good, then we have a verdict of not guilty. In this case, you're charged on the law of self-defense. The judge has given you that instruction. And I hit it first, I'll talk about it first because it's, again, the most important thing from my perspective. In this case, there are some other things that I'll cover before I sit down. And this was writing flows to have the last word with you. But the law of self-defense, the judge will give you in here. And what the key thing to keep in mind about the law of self-defense is that once that issue is raised by the defense, by the defendant in the defense, Once the issue of self-defense is raised, then it becomes the obligation of the court to give you the law of self-defense, provide that to you and instruct you that the burden to disprove self-defense rests with the state, not the burden of the defendant in this state, any defendant, to prove to you that he was acting in self-defense. Let that sink in. Maybe that may be counterintuitive to what you thought the law was, but it's not the obligation of anybody charged with an assault, murder, aggravated assault, any of the types of offenses that involve assaultive type behavior to prove self-defense. It used to be the case that defendants had to prove self-defense. That law was changed. And the state looks very favorably upon self-defense, so the law was changed to say that when the issue of self-defense is raised by the defense, by the defendant, the court charges you on the law of self-defense, which Judge Holmes has done, and it becomes the burden of the state to disprove self-defense beyond a reasonable doubt. So you may ask yourself, well, how do you prove something didn't happen? How do you disprove something? Well, that's up to the state. And again, I'm sure Mr. Maserati has some arguments to you why you should believe beyond a reasonable doubt that he's disproved self-defense, and I'll let you, obviously, he will assert those to you. But it's important that you keep in mind that the standard and the burden that the judge has imposed, as the law requires, is that you have to believe beyond a reasonable doubt that the state has disproved self-defense. In other words, if you don't know whether it was self-defense or not, in your mind, you don't have a reasonable belief or believe beyond a reasonable doubt that it was not self-defense, the verdict is not guilty. It's as simple as that. He has to convince you beyond a reasonable doubt that self-defense was not applicable in this case, did not exist. And the court tells you in the instructions, actually give you a detailed way that what you have to find in here, that you're gonna see when it says application of law and facts. And I put to the side, there's 1 and 2. The first is what I would call a subjective standard. He has to prove to you beyond a reasonable doubt that the defendant did not believe his use of force was immediately necessary to protect himself against Jason Warden's use or attempted use of unlawful force. So what that means is he would have to prove to you beyond a reasonable doubt that subjectively, he actually did not believe it in his own mind. He didn't believe it. Okay, that's the subjective standard. The second one here is what I would call, and these are not words, the objective standard. This is that he has to disprove beyond a reasonable doubt that the defendant believed his use of force was immediately necessary to protect himself, but the defendant's belief was not reasonable. So if you would believe beyond a reasonable doubt that the defendant's belief on an objective standard was not reasonable, what he actually believed, right, his actual belief, what he actually believed. If you believe beyond a reasonable doubt that that was not reasonable, then that would overcome self-defense. So sorry, subjective standard, he actually did, but he actually subjectively did not believe his actions were justified or reasonable subjectively, or objectively, if he did actually believe his actions were reasonable on an objective standard, you looking at it from what a reasonable person would think, they were unreasonable. If that makes any sense, but we'll have to read it, figure it out. So either of those ways is how the state has to disprove beyond a reasonable doubt. So I would suggest to you that, that's probably going to be a large part of your deliberations. I will suggest to you also that you have to find, first of all, you have to find Jason Warden credible as a credible witness to even get to the point of self-defense. This is what actually happened. I know Mr. Poirier testified that he did strike him, so I don't think there's any question about that. But as far as the complete context of the actions and how they occurred, the judge's instructions are in here, just among other things, that the fact that Mr. Warden has a prior misdemeanor conviction for it's a misdemeanor crime of moral turpitude conviction that's admissible for you to evaluate his credibility. That's something that you can consider and give it what weight that you think, but I think it's important that Mr. Warden has a previous conviction for lying to the police. He was convicted of failure to ID fugitive, which means he had a warrant And that he gave deceived the police. That was the offense. And he admitted to it when I was questioning. So he has a prior conviction for lying to. And that's something that you should keep in mind when you look at those videos and he's interacting with the police. This is a person that has a previous conviction for lying to the police when he's talking to the police on the videos. You can give it what weight that you want. You don't have to give it any weight at all. Maybe it doesn't matter at all, but it's there for you to consider. The court is giving you an instruction that you can consider how many, whatever way you want. And again, other things that you could consider about his credibility. I mean, he's on the tape representing that, you know, this is his wife, this is his house, this is his stepson. None of that's true. That's not his wife, that's not his stepson. He may live there, that's not his house. Those are things that you could consider on his credibility, is what, it's how he relates this occurred. As far as his actual version of what occurred, this is important to realize that this case was originally indicted as a felony burglary. That's how it started out. You look at State's Exhibit 2 toward the end of it, you'll see the, and I think it's probably, it has to be on 1 too, because it's the officers talking to each other, so it should be on both the body cams, but I know it's on 2. Where the officer said, well, we have enough for burglary, we got burglary on him already. I mean, they say that on the tape, that they got burglary. And again, the law of burglary, when you think of it, is, well, somebody's breaking into my house to steal my stuff. Well, that's one way to commit burglary. Entering, intentionally or knowingly entering a habitation without the effective consent of the owner or personal superior or right of control with the intent to commit a theft. Well, that's burglary, right? It's also with intent to commit assault. Either one. So you can intentionally or knowingly enter the habitation of another without effective consent with the intent to commit an assault. Well, that's burglary by habitation, which is what Mr. Correa was originally charged with. And if you listen to the testimony of Mr. Warden, that's exactly what they proved, right? If you believe that beyond a reasonable doubt. I mean, I know he's down here charged with assault, but they proved burglary of a habitation, which is what this case was originally charged. And he was indicted. We had a court date down the hall, and for whatever reason, they dismissed it. And I'll represent to you, it wasn't an agreement. It was set for trial. We were ready to try this case, and a jury, 12 people instead of 6, down in felony court, would have listened to the same evidence, and the judge would have instructed them on the law of burglary habitation. Self-defense would even been an issue because it's intent to commit an assault. And they'd have gone back and decided whether Mr. Correa was going to face up to 20 years in the penitentiary for burglary by habitation on those facts. Because he testified, he got bum rushed inside of the residence that Mr. Correa did not have a right to be in, wasn't his house anymore, and that he was assaulted. And again, it's not even that he was assaulted, he just has to have the intent to assault, right? I mean, under the law, you can stick your arm through your neighbor's door, right? You're entering a habitation. So all you have to do is intrude a portion of your body with the intent to assault them, right? You don't even have to assault them, you just have to do the intent. And that's burglary of a habitation. For dead to rights, what he testified to legally is burglary of habitation, which is what they would have to prove down the hall. I don't know why they dismissed that case on those facts. I don't know, but they did. And so we're down here charging it as, you're hearing it as a misdemeanor 3 years down the road. All I can say is that if the state of Texas believes Mr. Warden's version of this, they really believe that, why aren't we charged? Why isn't this charged as a felony? And why aren't we trying this case as a felony on the facts that he testified to? If they think he's credible, right? If they, I mean, I'm not speaking on Mr. Maserati, it's not his decision to dismiss this case. I'm talking about your office, private state, DA's office. I don't know. Other than maybe they don't believe that he has sufficient credibility to get a felony conviction, and maybe they can bring it down here as a misdemeanor with states for more and just try it as an assault. But it's the same allegations. I mean, he didn't change the allegations to say what happened outside the house. So it's just an assault. It's not a burglary. No, what he testified to was burglary of habitation. So I'll leave that with you. I don't know. Other than if they really believe that's what happened, this should be a felony. as it started out in Judge Westcourt down the hall in 252nd. I don't know. So you could look at this and say, well, I don't even believe, Mr. Warden, although I think Mr. Fortier did, I mean, I'll concede he testified he was struck. So yeah, there was that. So really, your evaluation of the severity of the injury and what actually happened, again, you can consider that for what it's. The main thing is disprove itself. So that's the real crux of this case. Just a couple other things I wanted to touch on with you. Sometimes, I don't know. I'm up here having to anticipate what the state's going to argue, but sometimes, Mr. Fortier testified, well, he didn't go down and get a statement for the police. Sometimes prosecutors will say, well, if somebody's innocent, they didn't do it, then they should have gone down and talked to the police and gave their verdict on what happened. And I can tell you, I advise people all, I've been doing this a long time. And every time I very, very seldom would advise somebody to go down and talk to the police to give a version. Once the police have already started down the track that they started down, because you're not going to change that. You can look at that tape, and I'm not faulting this, but they're the police, and they're on the track of their own. The officers, you can listen to it. We've already got him for burglary. They already know what they're doing. So it's better to trust the jury instead of going down and trying to convince the police not to do something and beg and plead with them, oh, don't do it. They're going to do what they're going to do. Trust the jury. Tell your story to the jury. Wait for a jury. 6 people in this case, 7 if the counter alternate, from the community to listen to what you have to say. Let them decide instead of going down and trying to convince the police to beg and plead with them not to file a case when that's what they're going to do anyway. It's a waste of it. Trust the jury. And that's what I advise people. If you're going to hold that against him, not wanting to talk to the police, I'll put it against the he sit down and watch the counsel. Sometimes prosecutors, I don't know what I didn't argue with, well, it's innocent, they should go ahead and tell their version. Why did you do that? What do you mean you done something wrong? No. You just trust the people, trust the jury. And that's what Mr. Fortier did. As far as Mr. Fortier, you can look at him. And I'm not saying morally he's a better person than Mr. Warden, but just look at the way he's conducted his life, how he's living, what he does. If he really were intoxicated, he couldn't be going out and push boat, being drug tested, working at 4 in the morning the next day. Doing that, he has a responsible job. He's still doing it after 3 years. So what can you infer about that is that he must not be busting any drug test or alcohol test, but he's still working at that job after 3 years. He was not on any kind of felony probation when this happened, like Mr. Warren. And you're not instructed on this because it was deferred, but it's been raised. And I submit to you, you can consider the fact that at the time this occurred, Mr. Warden was on felony probation. Deadly conduct for discharging a firearm in the direction of a residence. You can consider that for what it's worth, and its credibility, whatever, however you want to consider it, but it's there. Mr. Fortier was visiting his son on this particular case. He observed conduct on the part of Mr. Warden. You can infer then the credibility from Mr. Fortier that Mr. Warden probably engaged in that conduct with his son. Mr. Fortier wanted to go discuss that with him. And yeah, he was probably mad, probably upset, as any of us would be when we see some man, let's say, disrespecting your minor son, your little boy. And yeah, I didn't want to be mad about it. They probably would be mad about stuff. So when he went to talk to Mr. Warden, he probably was not in the best set of minds, but he didn't attack him. Mr. Warden threw the first punch. Mr. Fortier told you that. He swung on Mr. Fortier, and Mr. Fortier defended himself. And the thing is, we don't have to prove that. You just have to have a reason to doubt that the state has failed to disprove it. All right, that's what you have to keep in mind. I would suggest to you that, given the facts of this case, given the credibility of the two witnesses, that the state has failed to prove you beyond a reasonable doubt that Mr. Porter was not acting himself, that's this particular case. And I ask you, implore you to return a verdict not guilty in this case, and see that justice is done.
Mr. Maserati?
Ladies and gentlemen of the jury, I also apologize for our delay in getting started today. Unfortunately, I cannot be as quick as Mr. Kimmler, because as you've been told time and time again, the state is the one who bears the burden of proof, so I have to make sure each and every one of you are satisfied beyond a reasonable doubt about what occurred on April 10th, 2023. It's a rather simple case. You told your story form. On April 10th, Mr. Portier went to Mr. Warden's house or residence, as Mr. Kimmler thinks it's very important to differentiate. As Mr. Warden was attempting to close the door, Mr. Portier busted his way in. They got into a bit of a scuffle. As you can see, chairs are knocked over. There's more of the chair. Any of you who cannot see, I will lay these out for you, and if you have trouble seeing TV, I would ask that you just ask to see these, ask someone to pass them back to you. Got into a bit of a scuffle inside the house, knocked over some chairs. Mr. Warden decided to defend himself, covering up his head when he got knocked to the ground. That's why we see injuries on his hand. I know it might be hard to see here, but I'll go with the back one since that's right in front of you and that's a bit of a glare there. There is clear knots, circles on his hand, resulting from being hit. I just can't have my cake and eat it too. I can't have this here and have y'all see everything, can I? Showing that Mr. Warden protected his head and was hit on his hands. But as he's not a trained boxer or someone trained in the martial arts of fighting, he also sustained wounds to his head. We see red marks here on the back of his head, redness on his ears, more redness on his ears. Again. And then we see that he was cut. There was an abrasion that caused bleeding to the back of his ear, as you see there. Simple case. You heard Mr. Portier, Mr. Portier tell you himself that he fought and hit Mr. Warden. There's not much reason to belabor that point. That is not where I want to go. We still have a bit of that checklist or that recipe as Miss Nixon told you about. And from what I've seen so far, you basically have everything. By raising self-defense, Mr. Portier, William Ray Portier, has conceded most of the issues. We know that this occurred in Jefferson County, according to the officers and Mr. Warden himself. William Ray Portier told me himself that he did it on or about April 10th, 2023. We heard from the officers and Mr. Warden himself that it occurred on that date. Intentionally, knowingly, or recklessly caused bodily injury. You know, was his intent. He had intent to hit him. He claims he did so in self-defense. You can also find he did so knowingly or recklessly, but he tells you himself he decided to hit him. Caused bodily injury, as you just saw, all bodily injuries caused to Mr. Warden. And to Mr. Warden, you heard from himself that happened. So we have all the elements of the offense taken care of. The main issue for y'all to decide is that William Ray Portier testified he did this in self-defense. So you have to consider whether he acted in self-defense or not. So let's look at the facts, things we know for certain. We know that Mr. Portier was at the home on April 10, 2023. Where'd my clicker go? We know he decided to go confront Mr. Warden about something. We know that Mr. Warden's house looked like this after such confrontation. And we know that Mr. Warden sustained injuries to his hands and his head. Now let's look at what people have alleged. You heard Mr. Warden say that Willie Ray Portier was coming towards him in an aggressive manner. Perhaps about the son, what have you, that lines up. He tried to close the door and he pushed through the door. And then they got into a bit of a scuffle. Mr. Portier, as Mr. Warden had fallen to the ground, began punching him in the head about 3 or 4 times. And then Mr. Warden was so hurt by this, so hurt by his injuries to his head, that he could not even wear his required hard hat that he needs for his job and missed a week of work. You also heard that, according to him, Mr. Portier was clearly intoxicated. And he also told the officers he thought he was on steroids. When he came into this, he was a big man. He thought he was on steroids. And after Mr. Portier left, he heard him tell his neighbor, I did what I came here to do. You also saw on video, Mr. Portier's ex-wife testified that, or not testified, told the officers that she spoke with Mr. Portier on the phone that day. And that over the phone, she could tell he was intoxicated. We're not here to decide whether he's intoxicated or not. That can only go into whether you believe he did this, whether he would have been in a mental state more likely to commit this kind of offense, and what have you. You heard from William Ray Portier himself that he was at that front door to confront Mr. Warden about how he talked to his son. And Mr. Warden got agitated, lunged at him, threw a first punch, apparently missed, and Mr. Portier connected with a follow-up punch that put Mr. Warden on the ground. And all of that happened either on the front porch or at the entrance of the house. And you saw, well, before we get to that, if that all happened on the front porch, why does this house look like that? They clearly were in the house. You can use inferences. There's only Mr. Warden's testimony that they were in the house and these pictures to do that. But as we talked about in voir dire, you can infer things based on the evidence. And we can infer here that something happened within this house. We can also infer that there wasn't a single punch to Mr. Warden, as he has injuries on this side of his head, this side of his head, and on his hands. So he had to have been defending himself to sustain those injuries to his hands. That means that there has to have been more than one punch. And you saw in the video, his son, his little boy, went up and corrected the officers. No, my daddy was not drunk. He was not drinking. I don't know why he's saying that. He was telling the officers his daddy wasn't drunk. What did he not tell them? He didn't tell them, my dad's innocent because Mr. Warden threw the first punch. My stepdad, or stepdad figure, was the one who attacked him first. My dad was just defending himself. He didn't say that at all. In fact, he says quite the opposite. In Mr. Dew's video, he says, and I quote, I think Jason started bad talk. I think when Jason started talking to him, I think he started to get mad, reference to Mr. Portier. And I think he pushed him, and I think he punched him. I don't know. His own son tells the police officers that Mr. Portier made it physical first. That Mr. Warden was talking bad to him, he didn't like it, and he made the first contact. So when your jury charge tells you that self-defense does not cover conduct in response to verbal provocation alone, that's what Mr. Portier is trying to get you to believe. That his verbal contact, that his Mr. Warden's getting bad talking to him, gave him the authority to barge in that house and begin punching him. Now, you've heard about Mr. Warden's criminal history. Would it surprise any of you to know that people who have had crimes committed, or who have committed crimes, can still have crimes committed against them? You know, a person sitting in that chair 1 week can be sitting in that chair the next. The law is blind to that, and I hope you are too. Because you speak for the community with the decision you make today. What happened in Mr. Warden's past, whether he lied to a police officer about his name, does not change what happened to him that day. And if you want to lend or, take any of that with his testimony, you can. But you can't take that to these pictures. Because these pictures, if a picture is worth 1,000 words, these are 12,000 words worth of testimony telling you what happened that day. Mr. Warden has paid for his crimes. He was held accountable by the justice system. And he came here despite himself, because he told you he didn't want this to happen. He didn't even want to go. He was thinking about walking back to his car, but he came here because he wanted to hold Mr. Portier accountable for coming into his house, his residence, let's say, and attacking him. His house, his residence was his castle. And as for why this case was dismissed in felony court, perhaps it was the judgment call of the prosecutor. Our job as prosecutors are not to get convictions. It is to see that justice is done. So maybe they made the strategical decision that nothing puts Portier in that house. All that we have to put Portier in that house is what Mr. Warden says. There's no photographs of that. So maybe they decide the best way to get justice in Mr. Warden's case is to go what we can prove. What we can prove is that he was injured. And it doesn't matter whether it happened in his house or not, because that's not one of the elements on your recipe. All we have to prove is that he caused bodily injury. And as we talked about in Gordar, the burden that I have to meet and that you will be deciding this case on is beyond a reasonable doubt. As I said to you, that would be a B grade above. I submit to you that the testimony you have heard from the officers, from Mr. Warden, from the videos you've seen, from the testimony of the officers and Mr. Warden, that's all B grade testimony. You don't know if they're telling the truth, they're under an oath too, but you have to weigh their credibility. So I say it's B grade. It's good, it's all we can really ask for them. But the A grade testimony, A grade, B and above, that A grade is these photographs and those videos. So I submit to you that we have proven beyond a reasonable doubt that Mr. Portier did commit the offense of assault. As for self-defense, don't you know that Mr. Warden would not have tried to attack Mr. Portier? Look at him. Look how strong he is. He barely fits in that shirt. You saw Mr. Warden sitting up here today. Yesterday. You saw his demeanor. Not an aggressive person. Not a big, loud presence. He might have a little bit in his tummy, but that doesn't mean he's a big man going to try and fight this guy. So when in your charge of self-defense, you're said to believe, or you're asked, the defendant did not believe his use of force was immediately necessary to protect himself against Jason Warren's use or attempted use of force. If you believe Mr. Portier's testimony wholeheartedly, you believe it. If he's fallen from one punch, there is no reason, no justification to follow up on a man that's been knocked down by one punch with a few more to the head just in case. That's not self-defense. That goes beyond self-defense. If all that happened, if I only had one photo of a side of his head being red or one ear being bleeding and no other injuries, by all means, that makes it a lot more believable. But we know there was more than one punch. We know he was defending himself when he was being attacked. His hands are injured, not just his head. So there is no justification to keep hitting someone who's not attacking you, but simply defending themselves from your attacks. On top of that, he thought he was on steroids. What logical person is going to try and fight somebody who's coming at you angry and you think they're on steroids? Nobody. The evidence has all been laid out for you. And you have basically two tasks that you need to do. You need to look at the law, which will be provided to you in the jury charge, and look at the facts, and apply those facts to the law, and see if the law of Texas has been broken. And I say to you that it has. Let me make sure I don't have anything else before I give up the rest of my time. I believe that you have all that you need to make the right decision in this case, to see that justice is done, and hold Mr. Portier accountable for what he did. Not for self-defense, but for assault. For going beyond, even if you believe his statement wholeheartedly, that Warden attacked first, which I don't think there's any reason to believe that. You didn't hear that from him. You didn't hear that from his own son. Even if he did, him being on that ground, his injuries to his hand, his injuries to both sides of his head, show that he was not in any manner threatening Mr. Portier at that time. There is no self-defense to beat a man while he's on the ground, protecting himself from you. Thank you for your time.
Mr. Masrani?
Yes, sorry.
Okay, ladies and gentlemen of the jury, before you're released to go into the jury room, I need to inform you that one person in the jury is an alternate, and that alternate is not allowed to go into the jury room with the rest of the jurors. If something happens with one of the jurors in the case, then the alternate will be allowed to go in to deliberate with the other jurors. And the alternate in this case is Daphne Mai. Okay. Now, Miss Mai, you're the alternate in this case. You can either sit in the gallery or you can have a seat outside in the courtroom. And ladies and gentlemen of the jury, I'm going to hand this. The charge is going to be given to you by the bailiff. And once you're in the jury room with the charge, you can start your deliberations. Okay. At this time, ladies and gentlemen, jury, you can follow the bailiff into the jury.
Oh.
Order being recessed. We're gonna do, okay. Let the record reflect that you ready? Okay. Let the record reflect that the attorney for the state and attorney for the defendant are present in the courtroom. I have received a message from the jury that it has reached a verdict. Will the bailiff please bring the jury into the courtroom? Everyone please stand as the jury enters the courtroom. You may be seated. Jefferson County Court at Law number 2 is back in session. The court is in session in cause number 23 CCCR 2282, case of style of the state of Texas versus William Ray Portier. Let the record reflect that Mr. Portier is present in court with his attorney. And let the record also reflect that the state is present with their assistant district attorneys. Okay, foreperson. Have you reached a verdict in the case?
Yes.
Okay. Is the verdict unanimous? That is one that is agreed upon by all the jurors.
Yes.
Okay. Please hand the verdict form, just a charge in the form to the bailiff. Foreperson, is the verdict the unanimous verdict of all members of the jury?
Yes.
Okay. We, the jury, find the defendant guilty as charged in the information of assault causing bodily injury. Okay. Anyone like to have a jury poll? No? Okay. Let me do this. Mr. Masradian and Mr. Kimler, I'll be doing the punishment, and should I can do the punishment today if the state and the defense is ready for punishment. If not,
If the court doesn't require a pre-sentencing report, Your Honor, we don't object.
okay, defense,
Yes, Your Honor, if we can do a pre-sentencing report then before punishment, that would be preferred.
We would waive one if the state requests one, then obviously we'd have to get one, but we're willing to waive a pre-sentence report.
Okay.
Just to go forward today.
and state you're requesting that we give one?
Yes, Your Honor.
Okay. Okay, so we're going to, this case is going to be reset for punishment. Ladies and gentlemen of the jury, I will be doing the punishment. In a criminal case, the defense could request to have punishment done by the jury or the court. And so in this case, the court will be doing the punishment. We will have to get a pre-sentence investigation report. What a pre-sentence investigation report is, it's a report that is conducted by the Jefferson County Probation Department. And they will give us a lot of background information regarding this case. And based on that background information, that will assist the court as well as defense and the state with punishment recommendations. Okay. And so at this time, this case is going to be reset for a pre-sentence investigation report. And normally the pre-sentence investigation report, we usually give the probation department about 30 days to do it. Why? Because they have to do pre-sentence investigation reports for all 4 courts. And so that takes some time. And so we're going to order the pre-sentence investigation report to be conducted by the Jefferson County Probation Department. Ladies and gentlemen of the jury, first of all, on behalf of the citizens of Jefferson County, behalf of staff here in County Court at Law number 2, I'd like to thank you for taking your time out to serve as jurors in this case, as well as an alternate juror. Now, your service has ended. Please return your badges. And you could just put the badges on the countertop, and the bailiff will get those badges from you. Now, the lawyers may want to talk to you about your verdict after you leave the courtroom. You can talk to them if you want to, but if you do not want to talk to them, you do not have to talk to the lawyers. All right. Now, the other thing is, obviously, it's almost 7 o'clock, so our district clerk's office is closed. If you need an excuse, we have our court coordinator who's over here. She can provide you with any excuse that you need. As I mentioned to the other members who were on the panel, those members who were not selected on this jury, I mentioned to them that anytime that you're in the area of County Court at Law Number 2, you can come and have a seat in your courtroom. And the reason why I say it's your courtroom, because I'm only a public servant serving the citizens of Jefferson County. You're the citizens of Jefferson County. This is your courtroom, so you can have a seat in that area we call a peanut gallery. And as I mentioned, but you can't bring peanuts in here and eat because this is not the Texas Roadhouse. But you can come and have a seat in your courtroom. And I know that your service here these past couple of days, I'm sure you found it to be pretty interesting for those of you who have never served on a jury. And again, I also mentioned to the members of the panel that I usually give handshakes, but as I also mentioned that we have COVID in our community, so I cannot give you a physical handshake, but I can give you what I call an air handshake. So on behalf of the citizens of Jefferson County, thank you for your time and attention. Our bailiff, she has some letters that she would like to give to each and every one of you. If you feel free, you could drop us a line and just let us know about your experience here today. So at this time, your services are concluded. Each and every one of you have a blessed day. Okay? All right. Court is in recess. You need to get a letter?
Yeah.
Okay, you can get a letter.
Okay.
If you need an excuse or anything, you should get it from our court.
I thought you were in a hurry.
Yeah. Thursday is fine.
Thank you.
You talking about the PSI? What date you have?
We can do the 20th. See, they not here the week before.
No, they'll do it on Thursday. He works on Friday.
July 23rd.
Yes.
I told her if you spend more information, she's gonna get it.
Okay.
Uh,
Okay, this will conclude the trial of State of Texas versus William Ray Portier. Court will be in recess. Each and every one of you have a blessed day. Prosecutors and defense attorney, you are excused. All right. This is County Court at Law Number 2, Judge Terrence L. Holmes presiding. Everyone, please have a blessed day.
I'll email it to
do this.
Mr. Campbell. I'll email it to you, okay?